Thank you, Madam Chairwoman. I want to go ahead and jump in. I know that you've talked about a lot of the issues that I wanted to bring up, but Professor Bray and Mr. Paniccio, I'd like to turn to talking about the Administrative Procedures Act and vacatur. And one of the provisions of the Judicial Relief Clarification Act, which I am proud to be a co-sponsor of, amends sections 705 and 706 of the APA to limit relief to the persons before the court. My question to the two of you is, can you discuss the emergence of the APA vacatur and in the broader conversation surrounding universal injunctions and the importance of addressing that issue in any legislation that addresses the universal injunction problem that we have before us today?
Gladly, Senator. So the Administrative Procedure Act allows challenges and judicial review of agency action. And there is a vigorous debate among scholars about whether the Administrative Procedure Act should be understood as allowing a separate remedy of vacatur. I don't think there is such a remedy of vacatur. There's no traditional remedy called by that name. You won't find it in remedies casebooks or treatises or anything else. But there's a vigorous debate about that. What I don't think you can really debate is the interaction between vacatur and universal injunctions. So one of the things that we've seen, especially in the Biden administration, is litigants and courts were shifting from universal injunctions to vacatur, especially as appellate courts and some of the concurring opinions from the Supreme Court started to express more skepticism of universal injunctions. And that kind of switch is really important for a legislative solution. It means a legislative solution has to tackle the vacatur problem as well. Otherwise, you're just going to play whack-a-mole, and you're going to stop universal injunctions, and all the same things will be done by courts against agencies, at least, under the APA.
Thank you.
Thank you, Senator. Professor Bray is the expert on the history of this. I will just say that, as he has said, the issue of nationwide injunctions or vacatur is they're one and the same. At the end of the day, it's the court granting relief to parties not before it. There is the issue of the set-aside language in 706, and I think any legislation that's going to address the issue of non-party relief needs to take that on. To just take on injunctions would then, in most cases, allow courts just to say, well, I'm going to look over here to the APA and do the same thing.
Okay, thank you. Professor Bray, I want to get your response to some of the criticism we've heard for those that are opposed to curtailing universal injunctions. Let's start with the criticism that we shouldn't eliminate universal injunction because it could lead to inconsistency and an inconsistent application of the law around the country, or in some form of, as you have called it, disuniformity. As you've written about, it seems to me that the question is not about whether we have uniformity. It's more a question about at what level our legal system and our court system is such nationwide uniformity actually achieved. And so the process to get there and how we achieve that, I think, is kind of what is at question. What's your view on the question, and what's your response to the disuniformity criticism of limiting universal injunctions? And relatedly, is disuniformity an inherently bad thing?
So I think there's a lot of value to uniformity in the law. The question is how and when and who gets you there. And in our legal system, we get uniformity, but we get uniformity over time. And I think one of the striking things that you see for universal injunctions is they are proceeding on a premise that the first judge, selected with highly intense forum shopping and in a time of high judicial polarization, that the first judge who takes the question is going to be right. But often universal injunctions get reversed or narrowed on appeal, and so there should be no presumption of the first judge to tackle the question is the one who should get us to uniformity. Instead, the right way to get to uniformity is through appellate precedent, which, as Justice Kagan said, is the normal process.
Absolutely. Well, thank you so much for your time. Mr. Pananucci, as someone who worked at DOJ, what's your response to the argument of the universal injunctions are a good thing to help prevent having to relitigate the same issue in multiple jurisdictions?
Thank you, Senator. That's not how our multi-tiered hierarchical court system works. The whole point, the first ground for the Supreme Court to take jurisdiction over a case, the reason it will grant cert, as they say, number one reason they will say is if there is a circuit split. Well, how can we ever have a circuit split if we have a district court, which is lower than a circuit, issue a rule for the whole country?
Right.
The whole point is we have percolation. We have over 1,000 district judges in this country to apply their judicial reasoning. And Justice Ginsburg, it's in my written testimony, she had a very eloquent explanation of why percolation, why getting different decisions from different judicial minds is important. So it is not within our historical tradition to have one judge set a rule for the whole country and have that uniformity. That's not what our legal foundation is built upon.
Absolutely. Thank you so much. I appreciate it.
Thank you, Senator Britt.